Hi, I'm Manny Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. And in this very competitive market where so many buyers are including the Form 22AD, the increased down payment addendum, there is a question that constantly comes to the hotline email. The question says, if a buyer is a VA buyer, which necessarily means that the buyer's purchase and sale agreement includes the amendatory clause provision, and the buyer includes a Form 22AD, the increased down payment addendum, which provision trumps? Which provision controls the other in the event of a dispute? The amendatory clause says essentially the following. It says that if the buyer's lender's appraisal, the VA appraisal, comes in below the purchase price, buyer is excused from performance of the transaction. Buyer cannot be obligated to perform the terms of the transaction if the VA appraisal comes in low. And it seems like I always receive this question in correspondence with a VA buyer's offer, but of course the same thing would apply anytime you have any amendatory clause type loan. So that would include an FHA or a US RDA. Anytime there's an amendatory clause that's associated with the buyer's loan. So the amendatory clause says if the appraisal comes in low, buyer has the right to terminate the transaction. But it goes on to say the buyer also, however, has the privilege of choosing to bring additional cash to closing to make up the difference between the low appraisal and the purchase price. Not obligated to do so, and if buyer wants to walk away instead, they have the right to do so based on the amendatory clause, which is part and parcel with their VA loan. 22AD says, from buyer to seller, it's a promise that a buyer makes to the seller when a 22AD is included in the transaction, that seller, if my lender's appraisal comes in below the agreed purchase price, I will make up the difference in the form of an additional cash payment at the closing table. I will make up the difference between the appraised value and the purchase price, so long as that difference does not exceed whatever the amount is that buyer and seller agree on the Form 22AD. So the question that comes to me is this. Let's say that we have a VA buyer who has included a 22AD in their transaction for saying that they'll bring an additional $20,000 to the closing table, for example. And let's say their appraisal comes in $10,000 low. So their 22AD is going to bridge that gap, but the amendatory clause is sitting out here saying buyer cannot be obligated to close this transaction if they don't want to because the appraisal came in low. Amendatory clause, 22AD, which trumps in this scenario? And the answer is, I have no idea. If there is a dispute on this matter, it's going to be heard by a court, and a court is going to weigh the competing interests of the parties. From the seller's perspective, the seller is going to argue that, court, you must obligate the buyer to perform the terms of the transaction by bringing the additional down because the buyer led me to believe, induced me to accept their offer based on their representation that they would bring that $20,000. They made that representation in the face of the amendatory clause. The amendatory clause was part of the purchase and sale agreement. It was part of their Form 22A when they layered on top of the 22A, the 22AD, and said they would bring this additional cash. So they knew they had the right to do that. They said they would do that. They made that promise to me, court, and I relied on that when I accepted their offer. That's the seller's argument. The buyer's argument is, court, we are a veteran buyer, or we're an FHA buyer, a US RDA buyer. Being a buyer under that loan type gives us guaranteed rights through the program that seller knew we were utilizing when they agreed to accept our offer. They knew that we had this automatic guaranteed right to terminate the transaction if the appraisal came in low. And we exercised that right, and now the seller is saying, no, you can't do that. How is the court going to resolve this issue? I don't know. To my knowledge, no court has resolved this issue yet. And when the court does resolve this issue, it's unlikely to be in the context of a seller saying, I want the buyer to purchase the property. Instead, it's going to be a fight over the earnest money. Buyer's going to be saying, I'm entitled to recover the earnest money because I properly terminated in light of the amendatory clause. And seller's going to be saying, no, you didn't. You breached the contract because you were required to bring this additional $20,000 to the table. I don't know how a court's going to resolve it. But listing brokers and buyer brokers understand that this issue is out there. Before your client makes or accepts an offer with this potential conflict in terms, make sure they are make sure they are comfortable with the ambiguity of the situation. And if they're not, advise them to seek legal counsel before they proceed. Send your buyer, send your seller to talk to their own lawyer about what the likely outcome of this situation is going to be if there's a dispute before they enter the contract. Put your advice in writing, provably deliver that writing to your client, retain a copy in your firm's transaction folder. And if you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.